Right. I think that's enough time for to let the stragglers in. So I'm just going to get started on what I'm hoping will be around about a 10 to 15 minute talk through some of the basic mechanisms of a business renewal through the Landlord and Tenant Act 1954. So coming up to its 70th anniversary. And as many of you will know about the Act and having dealt with the Act in many of its provisions, it can often be quite an inflexible beast. Well, and that also applies to business renewals. And often when dealing with clients who often think of themselves as very practical, commercially minded people, the Landlord Tenant Act 54 can often seem very alien and unfamiliar to them. Now, the chances of a renewal of business tenancies under the 54 Act actually going the distance and going to a contested trial are relatively low. As a junior here at Chambers, I've not come across one that's gone all that way. And talking to a far more experienced practitioner here at the property team at King's, he can only really remember one case going all the way. But a low chance is very much not the same as no chance or zero chance. And it's important to know the ins and outs of the concepts as well as the practice and procedure to make sure that any application and claim are in the best possible shape to allow for both a clear-headed negotiation and hopefully settlement, so any application is unopposed to the court, or if all else fails, the best position at trial. So my talk is going to be structured in sort of three parts. First, looking at some of the fundamental concepts. Second, the biggest part, looking at litigation and practical points that arise that you should be aware of. And three, potential future, because the Law Commission is currently undergoing review of the Landlord and Tenant Act, specifically looking at business renewals, which is due to report in autumn of 24 of this year. So, first of all, why do parties need to go to the court in the first place? Well, as we all know, the whole policy of the Act is to give protection to commercial tenancies, but tenancies do need to be updated from time to time. And in some ways, the title of this talk in business renewals is a bit of a misnomer. What is happening is not that a tenancy is being renewed, but rather the process of ending one tenancy and for the parties to create a fresh new one in its place with sparkling new terms that everyone's hopefully in agreement with. And what the business renewal process under the Landlord and Tenant Act does is provide the mechanism for going about doing so. The first thing to note is that these tenancy renewals only ever apply to actual tenancies. Anything else, a license, a tenancy at will, short-term tenancies of less than 6 months, and certain excluded tenancies such as things to do with agricultural land and the like, they cannot be renewed through a 54 Act claim. So pop-up shops, farms, Jeremy Clarkson need not apply. Second, something that you should be aware of is that parties can contract out of these protections, though there are some restrictions. So if there is going to be renewal, just to make sure that there isn't they haven't contracted out, and if they have, whether that's been validly done or not. A lot of the process, which I'm going to be talking you through, is really processes of negotiation, court-mandated negotiation, and hopefully settlement. But it's important that you have a very clear idea of what issues in dispute are or what is being agreed, because the law, as we'll become aware, really rewards parties that are in agreement or are to be very, very clear about what the dispute in the renewal of the new tenancy is going to be. So moving on to the types of renewal, well, there are sort of four types. The main two are Section 25 notices from the landlords and Section 26, which is from the tenants. Section 27 is when a tenant doesn't want the tenancy to continue, and Section 28 is for when the landlord and tenant have agreed to a future grant of a tenancy on terms and from a date specified, which is then put before the court. And then the new tenancy agreement arises on that specified date. Now, the first stage of any of these applications are the notices. And I'm not going to sort of sugarcoat it, but there are lots of different forms, and the right form must be used as a part of the statutory process. So I've put the main forms on the slide. However, as I was looking through the Section 25 notices, I think I counted about 13 of them for various statutory provisions, different types of tenancies and the like. So it's careful to make sure, you need to be very careful to make sure that you're using the right one. There are a couple of absolute formalities that must be complied with these notices. So first one is that if the landlord is giving a Section 25 notice, is whether or not he's opposed to the granting of a new tenancy. And if it's not opposed, then the landlord needs to set out his proposal for that new tenancy in the Section 25 notice. And then the second one is you need to make sure you're using the right notice, and you also need to make sure that that you're making sure that you're having the notes that are required at the back of the notice, because the validity of the notice and making sure everything's correct, because once you've served particularly a Section 25 notice, it can't be amended or withdrawn. So it's very important to start off clean and on the right foot. Now, in between this, and also I've got here quite a good notice flow chart, which you might want to take a note of. Also, if you want, please feel free to drop me a line at I'll have my email address at the end, and I can give you these slides as well, showing you. So hopefully this shows you which is the right forms to use at the right particular point in time, and also the right provisions. Now, in between the notice period, the end of the notice period, and the issuing of your claims, called the statutory period, and it's very important that you keep an eye on this, because this is when most of the negotiations is going to be taking place. And the key provision for that is Section 29A and B of the Act. There's a slight difference in timing depending on who's done the notice of a day between the two. But the key thing is that you must make sure that you comply with the statutory period. If you do not comply with the statutory period and make the application late, the court does not have, particularly if it's on the landlord side, the capacity to determine a later out-of-time application. Now, the critical thing then is to make sure that if you're running out of time, that you make an application with the other party to extend that time also within time. So there's an unbroken chain of statutory periods. And the statutory period is, as I said, crucial, because during this time, it's really the negotiations. And what you're trying to do is take a potentially opposed application to an unopposed application, and so forth. Now, moving on to the procedure, the key points, key provisions to look at are CPR 56 and the attached Practice Direction 56, and you must be compliant with these as always. In terms of issuing the application, the High Court and the County Court both have joint jurisdiction, but the normal practice is for the claim to be started in the County Court Hearing Centre, serving the address where the land of the tenancy is situated. And most claims, hopefully, are going to be unopposed, and they'll be under Part 8, which I'll come to. So the County Court is almost certainly always going to be the one that you'll be issuing in. So then the key point then is, when you're issuing the application, is whether everything's been agreed, for which then it is a unopposed claim, or if it's then going to be disputed, therefore an opposed claim. So as you can see, unopposed claims, quite simple. Part 8, there is an amendment for the evidence. You don't need to file evidence, and the key provision there is CPR 56.32b. If it's opposed, then it'll have to be under Part 7, and then the provision is CPR 56.34, which I've put in there. There are specifications for the claim forms and requirements for them, and I've listed them under its PD 56 which you'll need to make sure that any claim form is compliant with. And following that, then the acknowledgement of service and the defence, if it's opposed as well, needs to be compliant with the practice direction. Now, the key thing about any sort of defence or acknowledgement of service is that they will have to, if it's opposed, filter into one of 8 grounds of opposition. In some ways, it's sort of, the way I was conceiving it was, it's a bit like a sort of inverse version of the residential tenancies if you're making a claim for possession. So a claim for possession residential, you need to make one of the grounds. Well, if you're opposing a business renewal, then you need to make sure you're compliant with one or more of the 7 grounds of opposition, which I'll come to. Now, one other feature about the Landlord and Tenant Act 54 business renewal claims that needs to be thought about at all times is that there's often a 2-step process for it. So the more complicated and contested the claim is, the more there are issues with, say, issues to do with validly issued notices, grounds of opposition, and the like. The more likely it is that the court will order a preliminary hearing to deal with those matters. So at that one, they'll deal with those issues, even to the extent of whether the tenancy applies to the Section 54 Act and therefore the matters. If that then happens, then we'll move on to the main trial or the main adjudication of the issues. So now I'm going to move on to the grounds of opposition. So here they are. There are 7 of them. The full one can be found at Section 30, the Landlord and Tenant Act, and I've just put in some sort of highlights of them. So they are safe repair, persistent delays, other substantial breaches, alternative accommodation, current tenancy created by subletting, intention to demolish or reconstruct the building, or intention to occupy the holding. It's very important, I should highlight at this point, and you'll see them in bold, A, B, C, and E, because the statutory language in these particular provisions under Section 30 is that the tenant ought not to be granted a new tenancy. And this gives the court a discretion to often go beyond the grounds and have regard to more other relevant circumstances, including tenants' conduct and behaviour, which many a landlord will want to make sure the court is aware of. So make sure that, if you're going to be opposing it, that you're making full use of the grounds of opposition. Grounds F and G, intent to demolish or intent to occupy, it's not enough for it to be a sort of abstract intent. There needs to be some sort of proof in establishing that the intent is real and will happen. So, for instance, if you're intending to demolish or reconstruct, it's not enough to say, I'm going to do this. You might need more evidence, such as planning permission or booking for a demolition team or something that goes beyond an abstract and saying that this is going to be real and not some sort of, as I said, vague aspiration. Coming to the terms that a court may order if the matter is opposed. Well, first of all, if it's all agreed, then the court will almost certainly be fine with that. The then rule is then, what the court thinks is reasonable in all the circumstances for a term of period no more than 15 years on the end of the current tenancy. Now, the court has a broad discretion, but generally speaking, it's subject to the terms of the current tenancy and to all relevant circumstances. And then the burden is on the party trying to vary a term in effect to justify it. But again, there is a broad discretion. So when advising clients, it can often be difficult to say where a court will go or not. And this all builds into pressure for settlement and negotiation and making sure all the terms are agreed before issuing the claim, so it's unopposed. The one exception to that really is to do with rent, and that's under Section 34 of the Landlord and Tenant Act. So the court will, if the parties can't decide, the court will need to decide what the rent should be, having regard to the other terms of the tenancy, what the rent can reasonably expected to be on the open market for the area, and the like. So this is where often expert witnesses, if it goes to trial, will be required, and almost certainly both sides will want to have their own expert testifying or providing evidence on their behalf, and therefore often then questions about whether hot tubbing will take place. So I hope that's a summary, that's enough of a thorough enough summary of the key points of a 54 Act business renewal claim, and the clunky mechanism which currently is established for that. As I said at the start, the Law Commission is currently looking at this, actively looking at it, I think partly because it's the 70th anniversary coming up, and also that there has been many complaints from lawyers, practitioners, landlords, tenants that the Act doesn't quite work for today. So the last time I had a look, it was saying autumn of 2024, but it seems to be a bit of a movable feast because it was supposed to be the end of last year. So who knows when it will actually report. And also, if you have just my sort of somewhat cynical eye, there seems to be quite a broad scope of what they're trying to achieve, but they don't really have any sort of particular focus on what they want it to happen. So potentially the consultation paper will probably have, there'll be either tinkering around some of the sections, which will then lead to some reforms. Potentially, maybe there'll be a fundamental change. And of course, with any Law Commission report, it's sometimes a bit of difficult to know if it will ever actually happen, given political traction, time in Parliament, and the like, and the timescales of it. But as practitioners, I suppose we should be aware that there might be change coming up in this particular area of law. So that's the end of my presentation today. I find it quite awkward sometimes on Zoom to do question and answers on the technical side, and also the nature of the topic often means direct questions or just having a conversation is often better. So you'll see my email address there, asmall@kingschambers.com. If you have any particular questions that might apply, please feel free to drop me a line and I will get back to you.